Welcome to Canadian Justice. I'm K.R. Davidson. I have the pleasure of guest hosting today's show, and what a show it will be. We are going to review a showdown between the government and Parliament, which has now roped the courts into the mix, which is making history in the area of constitutional law. The issue relates to the Public Health Agency's firing of 2 scientists in Canada's highest security lab. The firing raised concerns of possible Chinese espionage, and a special parliamentary committee subsequently demanded Public Health to provide the reasons for the firing and the documents relating to the alleged breach. The government ultimately declined to do so, and the Speaker of the House, in a rare act, reprimanded the Public Health Agency. The government has stated that a section of the Canada Evidence Act prohibits the disclosure of the documents that might threaten Canada's national security, and the House has maintained that its constitutional privileges are not subject to those limitations. And on this note, we introduce the courts. The government, in an attempt to shield the disclosure of the documents, has filed an application with the federal court against Speaker Rhoda. And the Speaker has countered with a motion stating that the court lacks the jurisdiction to review decisions of the House and that the application must be struck. This is the first time in Canada's history that something like this has occurred, and is likely the first time in any commonwealth country that a government has requested the courts to limit the inherent rights of Parliament. And with me to discuss this is former Speaker of the Senate, Senator Leo Housakos, who will be joined, and we will be joined later by some of the leading experts in this area to unpack the details. Senator, thank you so much for joining us today, and thanks for bringing the wealth of your experience as a former speaker to be able to unpack some of these details. Can you give our audience a bit of an overview? How did all this come into fruition in the first place? And then we can start to unpack some of the details of this showdown.
Good to be with you today. This is a very important issue. This calls into question the supremacy of Parliament, our very democracy. We're talking about the Winnipeg Microbiology Lab, a center of research which is, of course, respected around the world, which is so important to Canadians, particularly because it deals with viruses, it deals with dealing with pandemics. And we have a serious case before us right now. We're talking about 2 scientists who had the most highest security access to information, to patents, to formulas, to research that's being done in that center on behalf of Canadians. And the accusations are serious. CSIS and the RCMP discovered that they were sharing that very sensitive information with one of Canada's biggest enemies right now, the Beijing regime. Of course, steps have been taken. And if I believe that once they got fired, it doesn't end there, and it doesn't end with a CSIS or an RCMP investigation. Parliament has the right to have oversight, has a right to call into question the government. After all, democracy and Parliament is all about keeping the government to account. So Parliament, I think, did its job.
Yeah, so help us out here, Senator. You're a speaker. How does this happen? I know that there was a Canada-China special committee set up to be able to review this. What's some of the process for the House to be able to ask for documents like this? And then how does the Speaker get involved in something like this?
Well, the House has right now the Canada-China Committee, which they had a motion on the floor of the House of Commons. They are looking and investigating at this particular issue. So they called upon the government to provide documentation. How the Speaker got involved is in normal instances, a government that respects the right of Parliament would provide those documentations to this House of Commons committee. The argument of the government, of course, that this is top sensitive information and they can't share it just doesn't hold, because there are processes in place in Parliament where all parliamentary committees in camera and with procedures that are set up with the law clerk will provide the security to highly secure information while they do their work. The House of Commons, of course, through the Speaker, called upon the government to provide this information. The government has refused. In essence, the government has taken it a step further. After the House also took another unprecedented step of subpoenaing the president of the Canada Public Health Agency, Ian Stewart, and they instructed him to also be not compliant with the House of Commons by calling upon, imagine the government of Canada calling on a senior civil servant, somebody that works for the people of Canada, not to respond to requests from Parliament for documentation. So we have contempt of Parliament by the government. The government has created a second contempt of Parliament by asking a director of an agency not to provide information. Now, the Speaker,
No. I want to thank you just for coming on the show and being able to expand on this, especially from your purview as a former Speaker of the Senate. It's a bit of unprecedented times in that respect. So thank you so much. Stay with us. We'll be right back.
Thank you.
Welcome back to Canadian Justice. I'm joined now by Professor Alford, who's a professor at Lakehead University in their Faculty of Law, and is the author of a new book called 7 Absolute Truths, which will focus on some of the parliamentary issues at play here. And I'm also going to be joined by Stephen Chaplin. He's the former senior legal counsel of the House of Commons and is a fellow with the University of Ottawa's Public Law Centre. Thank you, gentlemen, for joining me, and thank you for the wealth of experience that you get to bring to the table on this issue. A very interesting one at that, but I'm very interested to say, what are you seeing as the salient issues? And maybe, Professor Alford, if you might lead us off, that would be great.
It's quite remarkable the government's bringing this lawsuit. It's such a question of fundamentals. It's raising things that haven't been adjudicated in Canada for hundreds of years because we took them for granted. We took for granted the idea that the government was responsible to Parliament. It's the principle of responsible government. And we took for granted the idea that Parliament had inherent powers to legislate that clearly include the ability to get any papers in front of it that it wants, and that any government that would invoke any reason for withholding them would be clearly guilty of contempt of Parliament, and that going to court in order to block that kind of a judgment, or indeed that production, would be an abusive process. And now we're forced to address these very fundamental issues from a very theoretical perspective.
I can't imagine being the jurist that actually has to be dealing with this issue before them. So, Mr. Chaplin, give us an understanding of what you're seeing and some of the issues that are before us.
Well, I think that the principles that Professor Alford has talked about basically find their way into constitutional law. And it's about 2 or 3 things. One is about the independence of Parliament. There's also, and Professor Alford writes about this in his book, about the Bill of Rights of 1689 and provisions that find their way into Canada, which basically preclude the courts from looking at parliamentary processes and proceedings. In fact, there is a provision in Article 9 of that document that says that no proceeding in Parliament can be questioned or impeached by a court. And this is clearly a proceeding in Parliament. So there's a fundamental constitutional principle that's been in place for almost 400 years that's at stake.
So, Professor Alford, why is this important to the average Canadian that's watching this? Obviously, you're an expert in constitutional law, but why would the average Canadian viewer concern themselves with an issue like this?
What I want Canadians to recognize here, that it's not merely about the sovereignty of Parliament, but about democracy. If you elect a member of Parliament to go to Ottawa and they cannot pass laws that reflect the will of the people, because they cannot see what is going on, because the government is withholding the relevant knowledge from them, the vote that the people exercise to put that person in Parliament is worth precisely nothing. Sovereignty of Parliament and responsible government are necessary for our democratic process. So this is not merely an attack on Parliament, it's an attack on good government. It's an attack on the ability of the people to elect legislators who pass laws on behalf of the people of Canada.
So, Mr. Chaplin, you were legal counsel in the House of Commons. Have you seen anything like this or remotely like this in your history?
There was a similar incident that did occur. It didn't end up in the courts, but the Conservative government of Stephen Harper had a similar approach when it came to documents relating to the Afghanistan detainees, when they refused to provide documents to Parliament on exactly the same basis, national security basis. For the first time ever in the Commonwealth, a government was held in contempt of Parliament. And ultimately, the House of Commons voted non-confidence in the government, and there was a subsequent election. So that process played out the way it was supposed to constitutionally, but the same problem arose. And this time, instead of having it play out in Parliament, the government is trying to bring the courts into it. So it's a similar problem, but a different process the government is using.
So we're actually seeing that it's an extension of what we saw, and that was Speaker Milken's ruling against the Harper government. But we're seeing an extension of that, and we're going to be going to a commercial message in a bit. But there's a lot of argument stating that there's national security interests, that there's the Canada Evidence Act that is supposedly protecting these interests. And so we're going to unpack some of this. And what we're also going to draw Professor Alford on some of your history to be able to say, how did all of these rights and this dynamic between these institutions come into play? And then ultimately, we're going to be taking a look at whether the court has the ability to even weigh in on this, which is an interesting question in and of itself. A lot to unpack, and I'm sure it will be exciting. Stay with us. We're going to be back after these commercial messages. Welcome back to Canadian Justice. We're here with our show talking about a showdown between the government and Parliament. Professor Alford, obviously you have a rich understanding of the history that leads up to this. We have people that are saying, wow, the Canada Evidence Act specifically precludes any disclosure of documents that may be of challenge to national security in any proceedings, and they're saying possibly the House proceedings are included in that. Give us an understanding of whether that is or is not when we look at constitutional perspective.
Well, just as a preliminary matter, the Speaker has asserted in the motion currently before the federal court that the legislative history of the Canada Evidence Act makes it plain that it was not to apply to requests from Parliament. But essentially, this is why we need to understand the constitutional history, because the idea that a piece of legislation could entrench on these fundamental constitutional principles is patently absurd. And the idea that it would do so implicitly, that it would just say, well, we're going to take hundreds of years of constitutional history in which Parliament fought for and established the right, not merely to legislate free from any restrictions on the government, including withholding information, but to hold the government accountable. That this is all about the struggles in the 17th century to achieve the sovereignty of Parliament. And the idea that just in passing the Canada Evidence Act and including one provision which applies to quotidian matters, just everyday production of evidence, that would somehow hamstring Parliament in its fundamental constitutional function is patently absurd.
Okay, and so you're referring to 17th century history. Like, what is the history that was fought for, and what is that really? How does that translate to today?
It's interesting because the argument is always about national security. We talked about the Afghan detainee crisis. We're talking about crises in the 17th century where the government, at that time the king, Charles I, says, well, there's all these emergencies, Spain is threatening war. And Parliament says, well, can you explain to us what's actually happening here? We don't understand why we're being taxed without our consent, why you're levying these fees purportedly for military preparation in these novel ways. And the king just says, well, you don't get to ask me that. Right? This is super secret stuff, right? And what we say national security now, in the past, it would have been extraordinary prerogative, things of that nature. And Parliament just didn't take it lying down. There were various showdowns, including in 1839 and then in 1639 and in 1642, when Parliament established that it would not accept this. And that led directly to the Civil War, and then it led to the Glorious Revolution, which established the basis for a constitutional monarchy in which Parliament plays the role of holding the government accountable.
I think you're prompting me to brush up on my history on these points. So, Mr. Chaplin, give us an understanding. You talked about this concept of accountability, where the government is accountable to Parliament. What is the significance of that, and how does that apply in this issue?
It applies because the government has to always have the confidence of the House, and which means the government's legitimacy comes from the fact that the House of Commons has said, we give you the authority to govern, but we also retain the ability to hold you to account, because we have to be able to demonstrate confidence. Well, if there are things that the government can hide from Parliament, essentially, then there becomes an area for which the House cannot hold the government to account. Or how does the House hold the government to account when it can't see those things that it needs to see? So the idea of, I have confidence in you and you are going to be accountable to me for it. How can there be areas where the House cannot see that information? How do you know whether or not you even have confidence that the government is doing national security in a manner that is proper? How do you hold them to account, and how do you say that I still have confidence in you to even carry out national security functions if you can't see the information?
Yeah, no, obviously there's limitation, and it appears that there might be a repeat of history. So Professor Alford, when you're taking a look at it now, it's gone over the courts to say, you know, is this properly within the jurisdiction? But there's some people questioning, saying even the courts can't even opine on this or don't have jurisdiction. We've got about 45 seconds left, if you might just start to touch on that.
Well, just Mr. Chaplin had it right. The idea here is the Glorious Revolution and its outcome, the English Bill of Rights, say that the court shouldn't be involved in this because you're bringing the courts into a political dispute, and you're exposing them to all kinds of pressures to which they shouldn't be exposed. And that principle just couldn't be clearer. It's so simple. What is done in Parliament may not be questioned in any place outside of Parliament, including the courts.
And you're referring back to, I think, the Bill of Rights, I think it's 1689, which Article 9 covers that off. So we'll maybe cover it off in our last part of our segment of how these constitutional principles still undergird the institutions that we have. It's a very interesting concept in and of itself. But another thing I want to talk about when we come back is how do we actually protect national security within Parliament? Because they're suggesting that it might be challenging. Stay with us. We'll be right back. Welcome back to Canadian Justice. I'm here with our panel of experts talking about a showdown between Parliament and government on a constitutional issue here. So, Mr. Chaplin, we were just talking about in our last segment whether the courts actually can even wade into this area. Obviously, the courts have had to make a determination of whether they can even opine on issues like this. Can you give us an understanding of the history in this area and what you might expect to see in this instance?
I'll make three points relatively simply and hopefully for the audience. First of all is, as we talked about, the Bill of Rights, that is in fact not just a statement on the freedom of speech in Parliament. It is in fact a constitutional injunction to stop the courts from looking at this. So there's a constitutional statement. The second is that the courts have, for those people who make the argument that, well, there's a statute, the courts have also made it clear going back into the 19th century and the Supreme Court of Canada in 2005 confirming that even if a statute has principles in it that ought to apply in a particular situation, if they fall within the parliamentary context, it's up to Parliament to determine how that statute would apply. So in other words, here we're talking about the Evidence Act and national security. Even if that act were to somehow apply, or the principles were to apply, it's up to Parliament to figure out how to apply them in their context. As Professor Alford was saying a few minutes ago, when the Evidence Act talked about the courts and having its processes, the courts have said, even if there is a statutory framework in place, in parliamentary context, it's up to Parliament.
Okay, so this is interesting. The government saying, hey, we can't release this because it's an issue of national security. You're alluding to the fact that Parliament actually has the ability to make not only the determinations on issues of the Evidence Act, but actually can control the process for issues of national security. Professor Alford, give us an understanding. How would the House deal with something like this to ensure that issues concerning national security are not compromised?
Well, it's been doing this for hundreds of years, at least if we apply this to the Westminster Parliament. The idea that a parliamentary committee cannot be conducted in camera, that there can't be disciplinary rules about what can and can't be disclosed, it just defies all this history. And just fundamentally, the idea is, well, the Constitution establishes, again through the Bill of Rights, that the chambers of Parliament are entirely responsible for their own disciplinary processes. They're given the right to regulate all of this, and they've done so. it's very common for parliamentary committees to be conducted in camera and under admonition that if things are disclosed, that they'll be disciplined. But most fundamentally, the idea that we can't trust members of parliament to obey these injunctions. Again, these are the people that the citizens of Canada have selected to have access to that information so that they can hold the government accountable and so they can pass laws to remediate abuses. So they are the ones who decide who can be trusted and who can't be trusted. And for the government to then assume that role and then say, no, we're the ones who are in charge and we don't think you can be trusted. It's just a fundamental reversal that takes us back to before responsible government, to Charles I, effectively.
Well, I thank you for highlighting the role of a parliamentarian, and you can even see the constitutional authority that's entrusted to those in that role. And thank you for coming on the show and enlightening our viewers on this very important issue. Canadians play an important and determining role in the constitutional process, in that they provide Parliament with direction as to whether the government holds the confidence of the people's representatives, our parliamentarians. Parliament is not merely the amalgam of various political parties debating their respective beliefs and positions. It is the very institution in which the government is accountable to, and as such, the legitimacy of any government is established so long as it holds the confidence of Parliament. Furthermore, Parliament is responsible for the business that the House conducts, and this is to the exclusion of the courts. Supreme Court Justice Karakatsanis stated that the courts and Parliament strive to respect each other's role in the conduct of public affairs. And as such, there is no doubt that Parliament's activities should proceed unimpeded by any external body or institution, including the courts. So what do you think? Is the government's application to the court against Speaker Rhoda wading into uncharted territory, or does Parliament no longer hold an interest to ensure that the government carries out its functions and respects its obligations? On this subject, constitutionally speaking, you are the judge. I'm K.R. Davidson. Thanks for watching Canadian Justice. Remember, keep examining and know that you are part of the solution.